When this case has been going on in the Supreme Court for some time. So there have been orders. The Supreme Court, of course, has said that we can't order the Parliament to frame any law, because the Supreme Court cannot issue a mandamus to Parliament. They can issue a mandamus to an executive authority, but not to Parliament. So the way that has been found to get around this problem is the technique which was developed in this Vishaka case by Justice J.S. Verma in the Supreme Court, where he said that where there is no law, say, to protect women against sexual harassment in the workplace, but a regime to protect women against sexual harassment in the workplace is essential for protecting their fundamental rights or their human rights, then the court can order the executive authorities to frame certain rules, or the court's orders themselves will serve. The court can make orders which will fill in the gap till the time that a legislation is brought. That same technique was used in the police reforms case, that till such time that legislation is brought for the reforms that the Supreme Court has ordered, till that time the orders of the Supreme Court would serve that purpose, or the government would have to, by means of executive orders, put in place a system for putting up police complaints authorities, or making police complaints authorities, making police establishment boards, making state security commissions, separating investigation from law and order, etc. So, in the street vendors case also, this is what we have suggested, and it is likely that the Supreme Court is very soon going to order that the national policy for street vendors shall serve as the law till such time that a law is framed by Parliament. So that means it will have the force of law, it will have to be executed by all the executive authorities, all the town vending committee which is supposed to be set up under this national policy, it will have to be set up by virtue of the orders of the Supreme Court, which will take care of many problems of these street vendors, which will prevent the kind of harassment that they are facing at the hands of the police and the municipal authorities. Similarly, for whistleblower protection, there is no law yet. A bill was brought in Parliament that is under consideration, but it has not been made into law. So this issue had been agitating the country for a long time. There have been a large number of cases where whistleblowers have been killed. There are a much larger number of cases where whistleblowers have been victimized administratively, harassed administratively. As you know, recently there is this case of Durga Shakti Nagpal, or even this Ashok Khemka, who are like whistleblowers who were trying to prevent illegality in their own departments, etc., and who have been victimized as a result of that. But there is no law yet. So, in this Satyendra Dubey's case, who was one of these whistleblowers who blew the whistle on the national corruption in this National Highway Authority, we went to the court in which we said that till such time that a law is brought on this issue, the government should be directed to frame administrative or put in place administrative rules by which whistleblowers will be protected from administrative harassment as well as from physical threats, etc. And the court did order the government to do that, and they were forced to bring some kind of whistleblower notification, in which the Central Vigilance Commission has been made the nodal authority. again, that has not worked as it should have, but it has to some extent helped. But it can be made to work much better if the courts were, hopefully in that same case, the court will issue further directions in order to see that it works better. So these kind of systemic reforms can be asked for through the judicial system in an environment where systematic violations of human rights of certain sections of people are taking place. Those violations are taking place because there is a complete absence of an appropriate legal regime which would ensure that their rights get protected, which will ensure that when their rights are violated, the violators could be identified. There should be a system for identifying the violators and punishing them. In such a situation, the court can and should be asked in such cases to even order systemic reforms even in the absence of a law. However, all this, our experience has shown that the courts become active in such matters usually when there is a lot of public pressure on account of civil society activism on those issues. Because there has been a great deal of civil society activism in India on a large number of these issues, particularly on the issue of corruption, therefore the courts have become more proactive, and therefore there is now talk of making the Central Bureau of Investigation independent of the government. I mean, the courts are discussing this issue as to how to put in place a regime by which the main investigating agency can be made truly independent of the government. So therefore, this has to be done in tandem with civil society activism. That's when the courts also become more active, more proactive, more effective in making such orders. So these are just a few thoughts that I had on this subject. Thank you very much.